So when we come back to why they didn't take the why the Supreme Court didn't take the Drake case, some of the speculation is we didn't have the 5 votes to win it. And some of the speculation is that it's Anthony Kennedy was the judge that they may not have. I don't know how true that is or not. And the reason why, you know, it may be legitimate, but I have reason to believe it may not be as well. And the reason being is when our McDonald case, the Heller case was before the Supreme Court, one of the things we had overcome that a lot of people didn't realize was in the Miller decision back in 1939, I think it was, the Supreme Court, they basically ruled that Miller's sawed-off shotgun did not reasonably resemble a weapon used by the militia and therefore was not covered by the Second Amendment. So what they're saying basically is, you know, in that ruling is that, you know, a so-called assault rifle is covered by the Second Amendment. But that doesn't mean that every gun is covered by the Second Amendment. Obviously, a sawed-off shotgun wasn't. Well, the gun that Heller wanted to, quote-unquote, legally own in his house in DC was a handgun. And it wasn't a style handgun that, quote-unquote, the military uses. So one of the things we had to figure out how to overcome was, how do you get all the judges that might say, okay, there's a Second Amendment right, but it doesn't apply to Heller's handgun, and therefore we're going to rule against it. And we had this thing, we had to come up with something that was something different, rather than military-style firearm that reasonably resembles something used by a militia. And the Second Amendment Foundation, in our brief that was done by a professor at a law school, we came up with this thing about commonly owned firearm, which is what you saw in the Heller decision, repeated in the McDonald decision. And that was an art form that commonly owned rather than, you know, militia-style weapon. And the person who raised that at oral arguments and really smashed the Solicitor General in the head on it, who, by the way, happened to have been Paul Clement, okay, who's been arguing pro-gun cases for us on our side since, hit him over the head with that, and Clement couldn't really respond or answer to it very well. The judge that came to our defense and pulled that out of our amicus brief was Kennedy. And that's what sold him to give us the 5th vote in McDonald and subsequently in Heller. So it's hard for me to say that he's the holdout vote and why we didn't get Drake to the court. It is possible that he's just not there for carry. It's also possible that just the overall public pressure and feelings because of Newtown and everything that's been going on politically with each other, it's so politicized. And quite frankly, in many cases, it's become toxic, the whole issue, that the court may have just decided, anyone may have decided, well, we're just going to bug off right now and not, and not hearing the gun case. Drake was the best carry case we brought to the court so far, for the Supreme Court to hear. I thought the Willard case out of Maryland was very, very good too. And also the one out of New York was very good as well, because the judges there were crazy in their opinion. They gave such rhetoric that there was no way you could justify. So where do we sit now? What could affect New Jersey next on the legal side? Everybody's heard about the Peruta case in California. But many people have not heard about the companion case that was argued and heard the same day, got the same decision. Because Peruta came out first and the media jumped on the word Peruta rather than the word Richards versus Yolo County, California, which got the same ruling. And actually, our ruling in that case, this Richards case, the Second Amendment Foundation case, we got a 3-0 ruling to Peruta's 2-1 ruling. There's a technical reason why we got 3-0. They were both heard by the exact same panel on the exact same day. But where we sit with this now, and this isn't publicly known to everybody, some of you who follow the internet a lot might know some of this, but what happened is in the case for Peruta against San Diego County, the San Diego County Sheriff, who was the defendant in the case, chose not to appeal it. And the County of San Diego chose not to appeal it. Subsequently, the state of California, the Attorney General has tried to intervene so that they can appeal it, and they've asked us to appeal for it to go en banc to the whole Ninth Circuit Court. Real quickly about en banc to the Ninth Circuit Court. For every Republican appointed judge in the Ninth Circuit, there's like 3 Democrats appointed. So the odds of getting a panel randomly picked that would be in support of Second Amendment rights is probably like winning the New Jersey lottery. It isn't very good. Now the question here, when it comes in our case in Richards versus Yolo County, the sheriff there has moved to appeal to hear it en banc. And the state of California has not moved to intervene because they can't, because we noted them up front that it affects the state law and asked them to be a participant in the case from day one, and they told the court, no, we decline. Now they can't come back and get involved in that case. So there's a possibility here, and of course the timeline for the motion from the Yolo County Sheriff in that case has already been running for them to hear the appeal. We may be jumping Peruta because the court there has to decide, do we grant California standing to even be involved in this case? And they may and may not. It's not clean, because what could end up happening is the case goes to the U.S. Supreme Court. The Supreme Court makes no ruling. They decide, hey, there was no standing to bring this case, because the state of California at this point doesn't have standing to bring it. And as a result, Peruta could go to the Supreme Court and do nothing and fizzle out because of standing question. The Ninth Circuit, knowing that, may decide to send Richards instead, because there is no standing question or problem with the Richards versus Yolo County case. And Richards is a very interesting thing. Richards is a female lesbian gay rights activist who's been threatened a whole lot of times, who marches in parades, and the sheriff wouldn't give her a permit. And the good thing in Yolo County's case is the sheriff there, while California is a May issue, like New Jersey, the sheriff in Yolo County won't give anybody a permit, period. In San Diego County, in the Peruta case, they do give out permits. They just give one to Mr. Peruta, who at the time was not a California resident, which also complicates the case. So there's a really good chance that, quote unquote, Richards is the one that ends up going, not Peruta, even though you never hear about Richards. Okay, but the problem still is the Ninth Circuit as a whole, getting them, if it goes in, if they choose to hear it in banc, and they may not choose to hear it in banc for some crazy other reasons, but if they choose to hear it in banc, the odds are we lose, and then we have to appeal it. Now, it's always easier to get the Supreme Court to hear a case when the law has been overturned by a lower court, and they're dealing with a law that's now off the books, and should go back on the books rather than taking it off to start with. So remember in the Heller case, DC appealed it. We won at the appeals court level. DC appealed it, and Alan Gore won at the Supreme Court only because DC appealed it. In the case of McDonald, that wasn't the case. We got lucky, and the Supreme Court took McDonald, which showed they were friendly to hearing cases on Second Amendment. So it's really hard to say what's going to happen. Again, because of them deciding on standing and then en banc before it goes to the Supreme Court, you might be looking at a couple of years out no matter what for that one. So that's where we stand on that. Now, some good news, there's really some spirits for you here. Albert, come up here for a minute. Albert here just got turned down from getting his concealed carry permit on appeal this past week, and had 7 days to be able to determine if he's going to appeal it in state court, and contacted me this past week. We talked on the phone, and the Second Amendment Foundation has decided to appeal this case and take another carry case to the state's court system. And I want Albert, just for a quick second, to tell you the 3 reasons what the judge gave on why he denied the permit.
The 3 reasons the judge gave Evan Knappett and myself were, so I'm a small business owner. The judge said you can shut down your business and find a job elsewhere. If you feel that your life is in so much danger, you can hire a security firm, which will put me out of business because I can't afford them. And reason number 3 is, if I give you a permit to carry, it will make you more of a target because a criminal is going to want to come after you knowing that you have a handgun.
What?
I swear to God, those are the 3 main reasons.
Oh, God.
Thank you. So at any rate, obviously that's ridiculous, and shouldn't stand any kind of judicial standard whatsoever, in my opinion.
Absolutely not.
And so we're appealing this, taking it back to the state court. Now, one of the other reasons why Greg may not have gotten hurt, that's all the speculation again, and it's just again more speculation, was there was a similar case running through your state courts that your Supreme Court accepted to hear in New Jersey. And it could be that the U.S. Supreme Court postponed and didn't say they held over ruling if they were going to take the Drake case one time, and then held it over the second time before they decided not to take it. They may have been wanting to see what New Jersey Supreme Court was going to do with the case in Jersey, figuring that maybe New Jersey could solve the problem by itself and we don't have to get the Supreme Court of the United States involved. Or if the Supreme Court of New Jersey does it wrong, it can still be appealed to this court and we can hear that case. So they didn't hear Drake, and right thereafter, what do you think happened? Your state Supreme Court reversed itself and decided, well, we chose not to hear the case after we said we could hear it, which is totally unprecedented. That could have been a reason why also. It could have been something as dumb as that. It could have also been as dumb as something like, you know, hey, we held it over once, we held it over twice, because we're waiting to see how many cases we might take. We just don't have room on our calendar for all of them. And even though to us this is the most important case they could hear, to them it may not have been, and they chose not to hear it. It could be something as dumb as that. It could also be saying, hey, you know, we have another shot coming out of California. Let's see what comes out of California. Because as you all know, we love to knock down the Ninth Circuit Court of Appeals in California. If they take this in banc and rule against us, boy, we'd love to put it back down their throat. It could be lots of reasons. None of us know what they really are. We just know we want this problem solved. Yeah. You know, and it's a problem that really affects about a half a dozen states, one way or the other, pretty heavily. New Jersey maybe most heavily right now. And so that's sort of where we sit on the legal side. The Second Amendment Foundation just filed another case, not dealing with Cary, but in Massachusetts last week, 2 weeks ago now, 10 days ago. Massachusetts has a consumer protection law that basically just speaks directly to firearms and considers certain firearms unsafe if they don't have a load magazine indicator without defining what that really is. And the states determined that Glock model, Revolutions 3 and 4, so to speak, are not safe, even though their state police use them. And so